This meeting of the Civilian Review Board to order. Good afternoon, everyone. First, we'll start with approval of the minutes. Hopefully, everyone has had an opportunity to take a look at the minutes. Are there any additions, edits, or other changes? Seeing none, I'd entertain a motion to accept the minutes. Thank you. May I have a second?
Second.
All right, all in favor? All right, ayes have it. Thank you. Before I turn it over to the Inspector General, I do want to take a note that this was the meeting where we were supposed to be joined by our newest sworn-in board member, Dr. Terrence Hinton. Unfortunately for us, but I guess fortunately for him, he has recently taken a position with the city, which would present a conflict of interest, and therefore will no longer be joining the board. So that does leave us with 3 vacancies still on the Civilian Review Board. So I would strongly encourage those of you in the community who have an interest in serving a term or 2 with us to please complete an application. We will be bringing applications to our community events and community meetings throughout the course of this year. So I'll draw your attention to our June meeting, which is going to be June 3rd, 2025. That will be happening at the Glenwood Community Center on 1888 Fairmont Avenue, and we will have applications there. So if you have an interest in serving in this capacity, we would welcome your application. And with that, I will turn it over to the Inspector General for department updates.
Yeah. Well, I was just moving that back. Good afternoon to the board. The quarterly report that we're going to just briefly go over some of the highlights has been emailed to all of the board members. This one is kind of lengthy. It's about, I want to say either 63 or 64 pages long, because we did do some additional things to the report, and I wanted to kind of share that with the board. So just kind of going over some of the highlights for the our first quarterly report. It always has the introduction and gives all the information about the office, our vision, our mission, and it gives you a little background about some of the investigations. But I'm just going to go straight to, I think this is going to be page 6. So, and if there's any questions afterwards, please feel free to ask any questions. So looking at the source of complaints, and this quarterly goes from January the 1st to the end of March 31st. So as you can see, for this quarter, for 2025, we ended up with about 253 citizen complaints. We also give you a comparison for 2024 so that you can just see the change. Some people might notice that the complaints are a little bit less, being 253 for 2025 quarter versus 2024. One of the things we strongly did in 2024 was trying to get out there, tell the community a lot more about who we are and what allegations we're able to investigate. So what you're going to notice more now is most of the complaints we get are going to be a little bit more focused into police misconduct and not them filing complaints in which we don't have jurisdiction to investigate. Going on further, a little bit, sorry. Can you hear me better? Okay, thank you. Looking at the breakdown for citizen complaints, intake was 170. Of those, you can say the total closed at intake was 170. Open for investigations for the quarter were 82. We still had some that are administrative hold. That's just looking for further investigation. There were 2 pending, but that gave us a total of, that's where your 275 comes from. That's in comparison again to the quarterly, which was in 2024. Gives you a further breakdown as to the complaints when it talks about insufficient information to proceed. It just gives you a further breakdown. I won't go into all of that again, but if there's any questions, please feel free. Kind of want to focus on when it says complaints open for investigations and closed. So for the first quarter, we opened 82 investigations, 72 were closed. We still have 21 that are on administrative hold. And then coming into the allegations, here's a breakdown of allegations. The big number will always, usually tends to be actions taken, not taken. Then we go with 15 being forced. We've got 19 that was for rude and discourteous. Another number was handling property, which was 16, gives us a total of 210 allegations. And as the report states, the allegations are based on the complaints that we get, just not necessarily allegation per complaint. So one complaint can have 2 or 3 allegations. When we look at the disposition of the investigations, we're looking at 35 were exonerated, 33 were sustained as misconduct, 122 were unfounded, 1 was non-sustained, inconclusive, and we did 19 administrative closures. One of the things we did differently, which is one of the reasons why the complaint, the report is 62 pages, is in the back you're going to see a summary. This was something that I know the board had talked about and asked for. So what we did is in the back you're going to see a summary of all of the cases for this quarter that was closed. So the summary is going to be a summary of what the complaint is about. This information pretty much comes from the first page. And then what we also added was another box on here that you'll be able to see what the DIG's disposition was, what the board's disposition is, and then we also tried to put on there what the disposition with the chain of command. Understanding that the chain of commands takes a while, so we may not always necessarily have that, but towards the end of the year when we do the yearly report, all of this information as it's coming in will be updated, and this will be something that when we do the second quarterly report, we'll update whatever information we have. So towards the time we get to the end of the year, this should provide information for the board where they will be able to see all of the cases that were closed for that year with a summary of each case and a little bit of the disposition. So we're hoping that this would be better information, not just for the board members, but our quarterly reports we also post on the website. So information for the citizens to be able to get that information and review that also. I'm just going, is there any questions? I know that this is kind of new information, but again, if there's any questions, please feel free to, follow up with me. I'm going to go to just the monthly. So one of the things we did with the monthly summary that I normally do for the month of April, we added something a little bit different here also. So not only do we give what the stats are for the complaints received and the investigations open, but we're also adding on there so you can see from the beginning of January, February, March, it gives you the different lines of how many reports that we have coming in each month. Just kind of gives you a little bit of a chart so you can see that. So just trying to give a little bit more clarity. That's basically all that I have. Are there any questions? Okay.
Thank you so much and your staff for that really thorough report. Is that something you're going to email to us? Or?
Yes, we did email everything out. So if you didn't
okay.
get, yeah, just let me know.
Oh,
Yeah.
okay, gotcha. Okay, thanks.
And again, the only reason we didn't print the quarterly report is the 62 pages, and we figure that would be something that the board would value, just kind of having electronic copy. And it gives you time to kind of go through and be able to read all of the summary for the cases, especially for the board members that didn't get a chance to kind of review those cases.
Thank you.
Yeah. Okay.
Thank you, Inspector General. All right, so I do know that Board Member Jones, Dr. Jones is on her way, but will be a little delayed. So Board Member Nathan, would you like to report out the?
Sure. Do you want me to do all 18 in a row?
Sure.
Okie dokie. Thank you. This is case number, I'm just going to, it's 2024-1359. Oh, I'm sorry. Is that the first one? I think it is.
Did you have 1183?
Let's see here. I don't see that. Let me just make sure that, yes, I do. This is 2024-1183. The complainant alleged that during a routine traffic stop, the officer rushed up to his vehicle with a gun drawn, threatened to shoot him, that the officer smashed his face into the rear window of a police wagon, and during the pat-down, the officer reached into his pants, under his underwear, touched his genitals. There was no evidence to sustain any of these allegations. The DIG recommended that counts 1, 2, and 3 be closed with a finding of unfounded. We agreed. And this was based on review of body-worn camera data, CAD data, and an interview with the focus officer. Case 1359, the wife of a CPD officer alleged that on 3 occasions from 2021 to 2024, she was physically assaulted by the officer, and on 2 other occasions, she was sexually assaulted. The complainant was interviewed by DIG and said she was satisfied with the investigation by the CPD IAB regarding all these allegations. She withdrew her allegations against her husband and refused to cooperate further. The officer completely denied the original charges of assault. As a result of that, the DIG recommended the complaint be closed as unfounded, and we agreed with the DIG. We had some questions about the case, but those were resolved through our correspondence with the DIG. This is case 2024-1657. This case arose as a result of a physical altercation between the complainant and her daughter. The complainant alleged that her daughter had smoked weed. The complainant and her daughter had conflicting stories regarding who started the physical fight. The complainant called CPD. She alleged that the officers would not provide their names and badge numbers, would not let her use the bathroom when requested, grabbed her aggressively when she was in handcuffs, treated her like she was the aggressor when she called for help. Officers arrested her even though she was a victim and would not provide a sergeant when requested. The review of BWC footage showed both officers did, in fact, give her their names and badge numbers when asked. The complainant refused to identify herself, which caused the officers to place her under arrest. A review of BWC footage showed that the complainant did have to wait to use the bathroom since the officer tried to get a female officer to accompany her, but weren't able to. She was provided access to the facility. She attempted to remove her clothes, and the officer briefly touched her hands to place them behind her back, which is part of CPD's transporting policy. And so it's recommended that these first 5 allegations be closed with a finding of unfounded, and there's no requirement by CPD to provide a supervisor upon request. And so that wasn't made into an allegation. In any case, we agreed with the findings of unfounded as to all of these counts. This is case 1691. The incident arose as a result of 2 traffic stops of the complainant. The first stop was for driving on the wrong side of the road. During that stop, the complainant's passenger was arrested. The complainant was told to go home and not follow the officer. The officer then relayed to other officers that if the complainant followed him, he would stop her for a tint violation and tow her vehicle. He then did stop the complainant for failing to signal. Based on the preponderance of the evidence, the DIG determined that the second stop for failure to signal was within policy as the violation occurred. However, towing the vehicle appeared to be retaliatory as the officer had predetermined to stop and tow if the complainant followed the cruiser. Additionally, the officer claimed to use discretion, while the officer claimed to use discretion in the first stop, he never informed the complainant of the tint violation. This appears to be a pretext, and so it was recommended that this allegation be closed as sustained. We agreed. This is 1742. This case arose as a result of an alleged assault against the complainant's coworker. The complainant alleged her coworker was assaulted, that the officers responded but didn't take any actions against the responsible individual, and the officers didn't run a warrant check on the individual. In regard to allegation 1, the officer completed a report for the alleged assault. The officers explained to the complainant and her coworkers the process to go to the prosecutor's office to pursue the charges. The officer said that the reason he did not arrest her was because there were conflicting stories regarding the alleged assault. So it was recommended that the allegation be closed as unfounded. We agreed. In regard to allegation 2, the officer revealed that the officer did complete a warrant check on the alleged suspect, and so it's recommended that that second allegation be closed as unfounded. We agreed with that as well. This is case 2025-002. This incident arose as a result of a fight between the complainant and another man. There was conflict in the witness testimony between the complainant, who said he was pushed by the other person into the path of a car, and a witness who said that the complainant stumbled into the street because he was drunk. The complainant repeatedly refused CPD request of him to get medical attention. The CPD called a medic anyway, and the complainant again refused any treatment by the medics. Let's see here. Concerning the allegation that he had been hit by a car, there was no mention of it in the report, but the complainant was visibly impaired. Had the complainant appeared to have visible injuries or stated he was injured, or if the driver failed to return to the scene, the officer would have been required to fill out a separate crash report, but the complainant refused treatment from the medics, said he was fine, he didn't need anything, and so the officer wasn't required to fill out a separate report. It was recommended that his allegation be closed with a finding of exonerated. We agreed with the DIG's finding. 2025-0005. This incident arose as a result of the complaint that the boyfriend of the complainant's ex-wife had assaulted the complainant's son at the ex-wife's residence. The complainant alleged that the officers failed to take enforcement action by neglecting to arrest the boyfriend in violation of a court-ordered stipulation relating to the conditions of his recognizant bonds. That's the boyfriend of the ex-wife's recognizant bond. In any case, the CPD officers who arrived at the scene found no evidence of any assault or any physical altercation between the boyfriend and the complainant's son. There was no probable cause for an arrest of this boyfriend, and without a judicial order to effect an arrest, the officer's failure to arrest was within CPD policy. DIG closed this case with a finding of exoneration. We agreed. 2025-0022. The incident arose as a result of the attempted theft of the complainant's car. The complainant alleged that the detective tried to brush this attempted theft under the rug. The detective claimed that he was simply trying to set expectations for how the case would likely go. The officer said that let me find the quote. He said it was unlikely that because they were severely understaffed, that they would be able to work the case in the manner that the complainant wanted it to be worked. And just because he explained that the cell phone recovered in the vehicle would have been stolen doesn't necessarily mean it would lead the police straight to the person. So the officer said he was trying to set expectations for how the case would likely go. The DIG closed the case with a finding of unfounded and said that there was no officer misconduct. We agreed. Case 2025-00, is this the same number? 25. Let's see here. Excuse me. 25. This case arose as a result of a car crash. The complainant alleged that the complainant alleged officer misconduct due to the failure to complete a crash report. That in addition, that the there was a failure to cite the other driver, and that the officers were involved in rude conduct. Since there were no injuries regarding the first allegation, there was no duty to file a crash report. Regarding allegation 2, the investigation found the officers were within policy and not required to issue a citation. So that was closed with a finding of exoneration. And regarding allegation 3, the investigation found no evidence that the female officer was rude or disrespectful or yelled at the complainant, and so that was closed with that allegation was closed with a finding of unfounded. We agreed with those findings. This is 2025-0038. This incident arose also as a result of a car crash involving the complainant's son and 2 other cars. The complainant alleged the responding officer advised her he cited the alleged at-fault driver, but he did not, and the officer advised her he would complete a police report. He did not. Pertaining to allegation 1, the investigation found no evidence to substantiate the complainant's allegation that the responding officer advised her that he cited the alleged at-fault driver, so that allegation was closed as unfounded. Regarding allegation 2, the investigation found no evidence to substantiate the complainant's allegation that the officer advised her he would complete a police report, and so that allegation was closed as unfounded. We agreed with the DIG. 2025-0051. This incident arose as a result of a dispute between the complainant and another person, in which the complainant alleged that the other person threatened to shoot her and her dog because the dog relieved itself by the person's car. The complainant alleged 4 things against the officer. First, that he allowed the gentleman to interrupt the complainant when she was telling her side of the story, but yelled at the complainant when she interrupted the gentleman. Second, that the officer went and spoke with the office staff and did not finish his conversation with the complainant. Third, that they didn't get the gentleman's information. And fourth, that the officer didn't complete a report for the incident. The DIG found, regarding allegation 1, that the complainant was never interrupted by the other party, but repeatedly interrupted the other party and yelled over the top of him. Complainant repeated her story to the officer multiple times, so it was recommended with respect to allegations 1 and 2 that they be closed with findings of unfounded. The investigation further determined that the officer did not get the other party's information. It did not complete a report. Complainant impeded the officer during his investigation, leaving him unable to complete a report or get a statement from the other party. The officer was informed by staff at the facility that similar incidents are frequent for this resident and that they could handle her concerns. Further, it was determined that the complainant was concerned with something she believed could happen, not something that had already happened, And so with respect to allegations 3 and 4, DIG recommended they be closed with a finding of exonerated. We agreed with the DIG's findings. 2025-0054. This incident arose as a result of an allegation by a woman that the complainant threatened to kill her and stab her mother in the neck with scissors. The police found the complainant in an upstairs locked bedroom. They spoke to the complainant through a locked door. He then let the officers in. The complainant alleged that the officers threatened to shoot him, although he had no weapon. In regard to this allegation, the complainant did have a pair of scissors close at hand and had allegedly threatened to use them against other occupants of the residence. The officers had their weapons unholstered and pointed at the ground while they advised the complainant to place the scissors elsewhere, and he complied. The officers' actions of unholstering their weapon and pointing them at the ground were in compliance with CPD directives for cases like this. The officers never threatened to shoot the complainant. Therefore, it was recommended that the allegation be closed with a finding of unfounded. We agree. 2025-0087. This incident arose as a result of a car crash between the complainant's son and another person. The complainant alleges that the officer was untruthful in claiming that he spoke to a witness who said that the complainant's son did not have his headlights on. In fact, BWC evidence discloses that the officer never claimed to have personally spoken to this witness. A medic told the officer that a witness claimed that both parties to the crash had not had their headlights on, but this witness disappeared. At no point did the officer tell the complainant he had spoken directly to the witness or that the witness personally provided him with this information. It's possible that the complainant misunderstood the officer or there was a miscommunication. The details documented in the traffic report were accurate. The complainant alleged misconduct through untruthfulness. The investigation found no evidence of such misconduct. So the DIG recommended the allegation be closed with a finding of unfounded. We agree. 2025-0098. This incident arose as a result of a disturbance outside the Hudson Market. The officer attempted to obtain information from the complainant, but the complainant refused. The officer then grabbed the complainant and directed him to place his palms together behind his back. The complainant resisted. They struggled together. The complainant alleged that the officer slammed the complainant to the ground, causing injuries to his tooth and arm, said he had a hard time breathing, that the officer would not provide his name and badge number, that the officer impounded the complainant's vehicle for no reason, and that the officer placed the complainant in handcuffs for no reason. In regard to allegation 1, the investigation found that the complainant was being detained for failure to comply with directions given by the officer. The complainant resisted being handcuffed, and the officer took him to the ground to handcuff him. There's no evidence that the complainant suffered the injuries he alleged, and so this allegation was recommended to be closed with a finding of unfounded. Regarding the second allegation, the investigation found the complainant did not ask the officer for his name. He did ask for his badge number, and the officer provided the badge number upon request, giving it to the complainant on the citation. Therefore, it was recommended that this allegation be closed with a finding of unfounded. Regarding allegation 3, the investigation found that the complainant stated he was driving a vehicle, and the officer observed that the complainant was driving a vehicle while his license was expired. So it was recommended that this allegation be closed with a finding of exonerated. That's the impounding. That third allegation is the allegation that the car was impounded for no reason. And finally, regarding allegation 4, the investigation found that the complainant was being detained for failure to comply with directions given by the officer, and so it was recommended that this allegation of officer misconduct due to handcuffing the complainant be closed with a finding of unfounded. We agree with the DIG's findings regarding all 4 allegations in case 2025-0098. Just have 4 more. This is case 2025-0103. This incident arose as a result of a request made by the complainant for a wellness check of his son. The complainant alleged that the officer called the complainant and advised him to stop calling for wellness checks on his son and advised him they wouldn't keep responding. And number 2, that the officer was rude and would not allow the complainant to speak or to express concern for his son's safety. Regarding allegation 1, the investigation found that the officer did in fact call the complainant and told him to stop calling for wellness checks and that she wouldn't keep responding. Therefore, it was recommended this allegation be closed with a finding of sustained. And regarding allegation 2, the investigation found that the officer and the complainant spoke over each other repeatedly. CPD is expected at all times to conduct themselves in an appropriate professional manner, being polite, courteous, and considerate of members of the public. So regarding this allegation, it was also DIG recommended that this be closed with a finding of sustained. So we have 2 sustained findings concerning the 2 allegations, and we agreed in case 2025-0103. 2025-0126. This incident arose as a result of a traffic stop of the complainant for turning into a driveway without signaling. The officer asked the complainant to roll down his window. He lowered it just a little bit, but the officer could not see in due to the tinted glass. The officer then opened the driver's side door. The complainant alleged that the officer opened his side door without permission, and second, that the officer would not provide his name and badge number when the complainant requested it. Additionally, the complainant alleged that the officer would not call for a supervisor when the complainant requested. There is no policy requirement for a CPD officer to call a supervisor. So, regarding these allegations, first, officers are authorized to order a driver from the vehicle during a legal traffic stop and may open the vehicle door and then issue the order if they chose. The officer elected not to order the complainant from the vehicle, advised the complainant that he could do so exercising discretion. It was recommended regarding this allegation of misconduct due to opening the officer opening the driver's side car door, that this allegation be closed with a finding of exonerated. We agreed. And in regard to allegation 2, the investigation found no evidence that the complainant requested the officer's name or badge number. So this was, DIG recommended that this allegation be closed with a finding of unfounded. We agreed with that. 2025-0130. This incident arose as a result of a traffic stop due to the complainant's car having 2 brake lights out. The complainant did not have a valid driver's license. Her son, who was a passenger, also did not have a valid license. The officers asked if he could pat down the son for weapons, and the son consented to the pat down. Because of the lack of licenses, the car was impounded. The officers conducted an inventory before impounding the car. The complainant alleged that the officer's search of the son was a violation of CPD policy. In regard to this allegation, the investigation revealed no evidence to substantiate the complainant's allegation. The investigation revealed the officers had valid reasons for the traffic stop, and that the officer's action aligned with procedures in this type of run, and not only with procedures, but case law supported the officer's identification and subsequent pat-down of the complainant's son, so it was recommended that the allegation be closed with a finding of unfounded. We agreed. Last one. 2025-0138. The complainant alleged misconduct by CPD from an alleged aggravated robbery. The complainant alleged her son was falsely arrested. The investigation found that the victim of the alleged aggravated robbery positively identified the complainant's son from the alleged incident. There was a very specific clothing description which the complainant's son matched. Based on the evidence reviewed, the officers had reasonable suspicion to detain and then arrest the complainant's son. Therefore, the DIG recommended that the allegation be closed as unfounded. We agreed. So, can I move to accept all of the DIG's findings? Or do I need to read off each of the numbers and specifically?
You can move to accept them all. I'll read the numbers off when I ask for a second.
Okay, so I move to accept all the DIG's findings regarding these, I think, 18 cases.
Thank you. Okay, so we've got a motion open on case number 24-1183, 24-1359, 24-1657, 24-1691, 24-1742, 25-0002, 25-0005, 25-0022, 25-0025, 25-0038, 25-0051, 25-0054, 25-0087, 25-0098, 25-0103, 25-1026, 25-0130, and 25-0138. Do I have a second? Oh. Sorry about, thank you. 0126, thank you for the second. Any questions or discussion on any of those cases? Hearing none, all in favor of accepting those, please raise your hands. No abstentions, no oppositions, motions carry. Thank you. All right, next I will turn it over to our committees 2 and 3.
All right, case number 2024-1693, complaint, this was the complaint against 2 Columbus police officers. The complainant alleged the officers failed to verify that an arrest warrant for her was inactive before placing her in police custody. The DIG investigation consisted of CAD information, review of BWC, review of Franklin County Municipal Court case information, and review of CPD policy and procedures. A telephone intake interview with the complainant and an in-person interview with the involved officer. With regard to the allegation that the officers failed to verify an arrest warrant, the investigation found the police response and the handling of the incident was within CPD policy. Therefore, the IG recommended that the allegation against the officers be closed as unfounded. In this situation, the system had not yet been updated. Our review committee reviewed, and we agreed with the findings. As to case number 2024-1696, this was an allegation of misconduct against CPD officers. The complaint stemmed from a traffic accident that occurred in November of 2024. The complainant alleged that a father was driving drunk with his 5-year-old son when they were involved in an automobile accident. The complainant alleged the father was found to be highly intoxicated per the lab results taken at Grant Hospital, being in the 300s. The complainant alleged 2 allegations. 1, there were no references in the accident report relating to alcohol usage. And 2, no field sobriety test was conducted, nor a citation issued to the father for being under the influence of alcohol. The DIG's investigation here consisted of an interview with the complainant, an interview with the focus officers, review of BWC data, review of CAD, event chronology, a review of the Department of Public Safety traffic crash report, review of Nationwide Children's Hospital medical records, and review of directives. As it pertains to allegation number 1, the officer did not make reference to alcohol usage in the accident report. The officer that completed the accident report and her partner advised the DIG that they did not smell any alcohol or see any indicators of impairment for a reference to alcohol usage to be put in the accident report. The investigation found the officer's actions to be within policy. Therefore, as to allegation 1, the DIG recommends that this allegation be closed as exonerated. As to allegation number 2, the investigation found the officers did not complete a field sobriety test or issue a citation to the father for being under the influence of alcohol. The investigation found no indication that the officer should have completed a sobriety test or issue a citation to the father. There was BWC footage, and it revealed that the officers arrived on the scene after a brief interaction with the individual who called 911 about the accident. And the BWC footage revealed the officer arrived on the scene, and after a brief interaction with the individual who called 911 about the accident, was approached by the driver involved in the accident, bleeding from his mouth and complaining of pain. The driver needed immediate medical attention, and the medics were already on the scene to treat the driver. Also, the officers explained that they did not smell any alcohol, nor did they see any indicators of impairment for a reference to alcohol usage, and the driver was coherent. The officers were within CPD policy in not conducting a field sobriety test or issuing a citation to the father, as medical attention was not the priority here. Therefore, it is recommended that this allegation be closed as exonerated. In this particular case, I did go down and see the BWC footage, and the officers did explain that the priority here was the welfare of the driver, and the medics were there, and he needed attention, and they did not smell any alcohol, nor were there any, to them, because of the accident, that could have caused him to maybe stumble out of the car, but there were no signs of impairment. So our committee reviewed it, and we agreed with the Inspector General on this case. Number 3, our committee, case number 2024-1703. This was an allegation of misconduct. In this case, the officers would not take any actions after the complainant reported her neighbor being assaulted. The complainant also alleged that the neighbor's fighting had caused some damage to her home. The investigation here consisted of an interview with the complainant, a review of CAD, review of BWC, and review of directives. With regard to this allegation, the investigation found the officers were dispatched to the incident location, conducted their investigation, and departed in accordance with CPD policy. Therefore, the IG recommended that this allegation be closed with a finding of unfounded. Our committee reviewed, and we concurred with the IG that there was no policy violation. The next case is case number 2024-1730. This was an allegation of misconduct. The complainant alleged here that, number 1, an officer did not provide a name when asked. 2, an officer was accusatory towards the complainant after only speaking with one of the involved parties. And 3, an officer threatened the complainant with jail time. The IG's investigation consisted of an interview with the complainant, a review of CAD materials, a review of BWC footage, and a review of CPD policies and procedures. With regard to allegation 1, the investigation found the focus officer provided his name 3 times upon request. Therefore, allegation number 1 should be closed as unfounded. With regard to allegation number 2, the investigation found that the officer spoke to the complainant and one of the involved parties in the same way with no change in demeanor or tone. Therefore, it is recommended that allegation number 2 be closed as unfounded. With regard to number 3, the investigation found that the officer advised the complainant that when the officers had arrived, they had seen the complainant in the driver's seat of a vehicle while it was turned on and while the complainant was intoxicated. Physical control. The officer advised that the complainant had violated the law and could be arrested, but he was giving the complainant a break. The officer advised the complainant of the potential consequences for this situation. The consequences stated were reasonable and viable. Therefore, it is recommended that this allegation be closed as unfounded. Our committee reviewed this, and we also agreed with the Inspector General as to this case. Case number 2024-1731. This was an allegation of misconduct by a CPD officer. The complaint stemmed from the focus officer investigating a burglary alarm. The complainant identified himself as a former CPD officer. He alleged that he was, 1, unlawfully detained for approximately 2 hours and 17 minutes without reasonable suspicion, and 2, he was falsely accused of possessing marijuana and of criminal trespass. The investigation consisted of email communication with the complainant, an interview of the focus officer, a review of BWC footage, review of CPD trespass authorization form, a review of police report from the incident, a review of CAD from the incident, and a review of CPD directives. The investigation found the officer did detain the complainant during the course of the officer's investigation. The detainment, however, lasted 38 minutes. The detainment of the complainant was within CPD policy, and the officer did have reasonable suspicion to detain the complainant during the course of his investigation. Therefore, the DIG recommends that this be closed with a finding of unfounded. With regard to allegation number 2, the officer did follow CPD policy as it relates to the complainant smoking marijuana. The complainant was smoking marijuana in public, and the officer did smell the odor of burnt marijuana. The complainant also admitted to smoking when the officer came in contact with the complainant. This statement was consistent with BWC footage. The investigation also found the officer did have the authority to trespass the complainant from the incident location. Additionally, the complainant was charged with use of marijuana in a public place. Therefore, the DIG recommends that this be closed as unfounded. We did review the case, and we agree with the Inspector General. Next case is case number 2025-0003. This was an allegation of misconduct. The complainant alleged, 1, the officer acted like he did not know how to proceed with taking a report because the victim did not speak English. Number 2, an officer did not obtain all the information for the report because of the difficulty communicating with the victim due to a language barrier. And 3, an officer did not get information on the victim's injuries. The DIG's investigation consisted of an interview with the complainant, interview with the focus officer, interview with a witness officer, review of CAD, review of BWC, and review of policy and procedure. With regard to allegations 1 and 2, The investigation found the victim was unable to provide information for many of the officer's questions, but the officer followed the relevant procedures and took the report with all the information that was available. While there was a communication barrier, it did not affect the officer's due diligence. Therefore, it is recommended that this allegation be closed as unfounded. The officer in this case did use the hospital's video translation service. With regard to allegation number 2, the investigation found the officers had the information on the victim's injuries captured on BWC. Additionally, the officers were told that a medical scan had been conducted of the victim, but the results were not yet available to them. Therefore, it is recommended that this be closed as unfounded. We did review this case, and the officers did everything they could to, they used translations, several, and they did everything they could and got all the information that was available to them. So we did agree with the finding of the Inspector General in this particular case. As to the next case, 2025-0013, this was a let's see, Inspector General, the complainant alleged the officers evicted her and her partner from their room at an extended stay hotel and informed her that she could be arrested for trespassing, for a trespassing violation for refusal to leave. The DIG's investigation consisted of an in-person intake interview with the complainant, CAD information review, body-worn camera footage review, and CPD policies, and also a review of CPD legal updates. With regard to this allegation that the officers evicted her and informed her that she could be arrested for a trespassing violation for refusal to leave, the investigation revealed the police response and handling of the incident was within CPD policy. Therefore, it is recommended that this allegation be closed with a finding of exonerated. So the rights in this case, the rights of hotel guests are not the same as the rights of tenants. They do not have the right to an eviction process. So our committee reviewed this, and we agreed with the Inspector General. Next case. Case number 2025-0029. This was an allegation of misconduct. The complainant alleged that the officers did not respond when she called and reported a neighbor had pointed a weapon at her. The investigation by the Inspector General consisted of interview of the focus officers, review of CAD, and review of BWC, and review of policy and procedure. With regard to this allegation, the investigation found that the officers did make telephone contact with the complainant and went to the incident location that she declared in her call for service. Therefore, it is recommended that this allegation be closed as with a finding of unfounded. The officer in this case called the complainant and knocked on the door of the next door neighbor and then ended the call. So the BWC footage in this case showed that the officer called the complaining witness, and during the conversation, the complaining witness explained the incident. She was agitated and hostile and demanded the officers to come to her to make a report. The officer stated that he would not, given how she was speaking to him. The officer ended the call. The officer then approached the neighbor's residence that allegedly had pointed the gun at her. Upon approaching the residence, they did discuss, you could see on body cam that she had called before. He knocked on that door and waited. There was no answer, and then they departed and ended the call. They never knocked on her door. So my committee reviewed this, and they found that this should have been sustained. We did not agree with the Inspector General. We felt that they should, you don't just not go to a person's home and complete the call because you think they might be obnoxious. They should have knocked on her door to see if she was, at least make a wellness call and find out what was going on. So in this case, we think that this allegation should have been sustained. Next is case number 2025-0032. This is case number, this is an allegation of misconduct, and the complainant alleged that an officer was driving at a high rate of speed without the use of lights and sirens in a construction zone. The DIG's investigation consisted of an interview with the complainant, review of CAD data, review of CVS footage, review of GPS data, review of IAB materials, and a review of policy and procedure. The investigation revealed although the officer was traveling at a high speed during this time, the complainant alleged, the officer was actively responding to a dispatched run. It is not always required for officers to use sirens or lights depending on the nature of the situation. As the officer did operate within CPD policy and procedure, it is recommended that this allegation be closed as exonerated. We did review this, and we believe that this was within CPD policy and procedure, and we concurred with the Inspector General on this particular case. Next case, 2025-0041. This was an allegation of misconduct, and the complainant in this case alleged, 1, the officers have been harassing him since his previous arrest. 2, officers pulled up at his residence while he was in his vehicle with weapons drawn. 3, officers searched his vehicle without his consent. And 4, unspecified officers have been sitting near his residence to follow and or stop people leaving his residence. Specifically, allegations 1 through 3 all stemmed from an interaction between the complainant and CPD officers on January 11, 2025. Allegation 4 was added after the DIG contacted the complainant on January 29, 2025, and the allegation stemmed from an interaction between the complainant and CPD officers on January 25, 2025. The DIG's investigation consisted of interview with the complainant, review of CAD, review of BWC, review of policy and procedure. The DIG made multiple attempts to follow up with the complainant after this initial contact on January 29th. However, the complainant failed to cooperate with the investigation. The DIG, however, did complete a full investigation. With regard to allegation 1, the investigation revealed no evidence to substantiate allegation 1 of harassment. The officers conducted a traffic stop, and the investigation was within CPD policy. Therefore, it is recommended that that be closed with an unfounded finding. With regard to allegation number 2, the investigation revealed at no point did the officers draw their weapons from their holsters during the stop. Therefore, it is recommended that this allegation be closed as unfounded. With regard to allegation number 3, the investigation revealed the officers conducted a traffic stop that aligned with CPD policy. The officers looked through the complainant's vehicle windows for items in plain view with their flashlights during the stop. An officer articulated to the complainant in the BWC footage, he can check the car for occupants and possible weapons. The officer's decision to look through the complainant's vehicle windows does not constitute a search and aligns with CPD policy. Therefore, it is recommended the allegation be closed with a finding of unfounded. As to the final allegation, number 4, the investigation revealed officers were not sitting near the complainant's residence and or stopping people leaving his residence. The officers did encounter the complainant's known acquaintance while on patrol at a location away from his residence on January 25th. However, the officers' encounter with this acquaintance, who at that point in time is just a member of the public, was of a consensual nature. The officers made it known to the acquaintance she was not in trouble and they were just asking to talk to her. The officers never indicated or impressed upon the acquaintance that she was not free to leave. Therefore, it is recommended that this be closed as unfounded. We did review the entire case, and we agree with the Inspector General. Our committee agrees with the Inspector General that this be closed as unfounded. So, there was no search, no weapons, no harassment, no questioning. As to allegations, or as to case numbers, 2025-0052. This was a referral from the Internal Affairs. Let's see. The email alleged that, let's see. The DIG received an email through the Columbus DIG email from the Columbus Division of Police Internal Affairs. The email alleged, 1, the complainant's constitutional rights were terribly violated. Number 2, the complainant was horribly discriminated against. And 3, the force used against her was an unjustifiable use of violent force that caused her to have bruises and to incur $50,000 plus in hospital bills. The Columbus DIG investigation consisted of a statement received from the complainant via email, a review of BWC footage, a review of CAD data, and a review of the police report. Regarding allegations 1 and 2, BWC footage showed the interaction between the complainant and the officer did not result in any policy violations. The officer was amenable and courteous throughout the encounter and had the information necessary to administer an involuntary psychiatric evaluation form known as a pink slip. Therefore, it is recommended that this allegation be closed as unfounded. Regarding allegation number 3, BWC footage indicates that no force was used during this call for service. Therefore, it is recommended that this allegation be closed as unfounded. We reviewed this and we concur with the findings of the Inspector General.
I just have one question about that. It said it was, came in from Internal Affairs. Was it a forwarded email from Internal Affairs? Like, did somebody else send it? Or was the email written by Internal Affairs and then sent to the DIG?
It was a, let's see.
I'm trying to get to who actually stated her constitutional rights were terribly violated. Was that somebody in Internal Affairs or somebody who sent it?
No, it was the complainant.
Okay.
It was in quotes. The email was sent through Internal Affairs, but the email alleged the complainant's, and then in quotes, constitutional rights were terribly violated.
Correct. So you're saying that was the complainant that stated that?
Correct.
Okay. Not a representative from Internal Affairs?
No.
Okay.
No. And then the complainant was horribly discriminated against. That was also in quotes.
From the complainant?
From the complainant.
Okay.
Yes. Then next is case number 2025-0077. This was, the complainant in this case alleged misconduct by Columbus Division of Police. On January 2nd, 2025, the complainant's stepdaughter was involved in an incident with CPD officers. According to the complainant, the stepdaughter had an active warrant for her arrest on January 2nd, 2025, during an interaction with the officers. The complainant alleged the officers did not arrest the stepdaughter for a warrant and instead issued the stepdaughter a citation, which she believed to be in violation of CPD policy. The Columbus DIG's investigation consisted of interview with the complainant, review of stepdaughter's Franklin County Municipal Court records, review of BWC footage, review of CPD incident report, review of U-10 arrest report, review of CAD dispatch report for the incident, and then interviews of all the involved officers and review of policy and procedure. So, okay. With regard to the allegation, the investigation revealed the warrant issued for the stepdaughter was for missing a court date on an active soliciting case. The investigation revealed the officers did not arrest the stepdaughter and instead wrote her a summons to court on the new soliciting charge out of this interaction. Also, the officers did not arrest the stepdaughter on her active court-issued order and warrant. The officers' actions to write a summons in lieu of arrest in this circumstance was a violation of CPD policy and procedure. Therefore, it is recommended that the allegation be closed with a finding of sustained. So we reviewed this, and we have to concur with the Inspector General that it is a violation of policy that they should have arrested her. The directive states that that the summons does exclude that for this is a sex offense, soliciting is a sex offense, and that an arrest should have been made in this situation, and not she should not have been ordered in on a summons. So we agree with the Inspector General here. Though the officers in this case did explain all their reasons why they thought that, why they didn't do that, but they didn't even call into municipal court to check to see if there was any way they could not issue the summons. It was crystal clear what they should have done. They were just not wanting to do it because they didn't want to cause the young lady more problems than she already had. But see, even with all that they were trying to do, we see what they were trying to do. They had to follow the directive in this case. So anyway, so we agree with the Inspector General. 2025-0079, the next case alleges misconduct by CPD officer. The complaint stemmed from the officer while off duty visiting a business that serves liquor. The complaint alleged that, one, the business denied the officer entry into the establishment due to the officer having a firearm, and the officer's insistence that he was allowed to resulted in the business calling the police, and two, the officer made a threat regarding the business's liquor license. So this investigation consisted of an interview of the complainant, an interview of 4 civilian witnesses, review of police report, review of BWC, review of CPD directives. With regard to allegation number 1, the investigation found the officer visited a business while off duty, and he was denied entry due to the fact that he was carrying a firearm. The investigation found CPD policy states, quote, full-time sworn personnel shall carry a loaded authorized firearm at all times. Additionally, the policy states, quote, justification for not carrying a firearm shall be required. In the state of Ohio, an establishment serving the public cannot prohibit or restrict sworn personnel from carrying an authorized firearm on the premises. Therefore, the DIG recommends allegation 1 be closed with a finding of exonerated. So, allegation number 2, the investigation found there was a disagreement between the officer and staff members of the business due to denial of entry. There was a discussion between the officer and the staff members regarding the law and the liquor licenses. Based on the totality of the statements and the preponderance of the evidence, it was found the discussion regarding the liquor license never met the threshold of being a threat. The officer explained he only attempted to explain to the establishment that they were incorrect as it relates to their interpretation of the law regarding having a liquor license and the specific denial of entry. Therefore, the DIG recommends allegation 2 be closed with a finding of unfounded. We reviewed this case, and there was the investigation consisted of many interviews. The Inspector General did lots of interviews and review of body cam, and we do agree with the Inspector General as to the outcome in this case. Next case. The next case is 2025-0101, and this was an allegation of misconduct. The complaint stemmed from the execution of a search warrant. The complainant explained the officers had a search warrant for his residence to look for weapons and ammunition. However, the complainant alleged the officers disconnected his interior security cameras while conducting the search. The investigation consisted of interview of complainant, BWC footage, relevant case law, Muni records, and CPD directives. The investigation found the officer did disconnect the complainant's interior security camera during the execution of the search warrant. However, the officer's disconnection of this interior security camera is supported by CPD policy and procedure. Additionally, the officers involved in the search were equipped with BWC and were recording during the search. Therefore, the DIG recommends this allegation be closed as exonerated. And we absolutely agree with this, and if they're following CPD policy. The next case is 2025-0104. This is an allegation of misconduct. The complainant alleged the officers did not take witness information or look at videos and were instead more concerned with who was in the vehicle with her. This was the evidence in this case used by the Inspector General was CAD, review of BWC, and review of CPD policy and procedure. In this case, the investigation found the officers were dispatched to the incident location, conducted their investigation, and then departed according to CPD policy. There was no witness information to take. The officer watched the video as presented by the complainant, and both the complainant and her passenger were asked once each by different officers if they were the only occupants in the vehicle. Therefore, it is recommended that this be closed as unfounded, and this was all on footage. This was an auto accident. We reviewed the case, and the committee concurs with the findings of the Inspector General. The second to the last case is an allegation of misconduct. The complaint stemmed from the execution of a high-risk narcotics search warrant by the INTAC unit. The complainant alleged that CPD conducted a search at the wrong address. The DIG's investigation consisted of an interview with the complainant, a review of BWC footage, a review of the search warrant from the alleged incident, a review of the forced entry report, and a review of CPD policy and procedure. The investigation found the INTAC unit conducted a search of the correct address. The involved personnel followed all appropriate CPD policies and procedures. The INTAC unit executed a search of an address based on a signed search warrant from a judge. Therefore, the IG recommends the allegation be closed as unfounded. That's it. Our review committee reviewed the case, and we concur with the findings of the Inspector General. And the very last case is an allegation of misconduct. The complainant alleged that an officer spoke with his juvenile daughter without a parent guardian present or without parental consent. The Inspector General's investigation consisted of an interview with the complainant, review of CAD, review of BWC, review of CPD policy and procedure. With regards to the allegation, the investigation found that a custodial interrogation requires officers to notify and consult with the juvenile's parents and to allow the juvenile to consult an attorney. However, there is no law or policy requiring a parent or guardian to be present or to provide consent for an officer to question a juvenile witness or a victim. Additionally, at the time of questioning, the adult female present declared herself to be the stepmother of the complainant's daughter and did not reveal her divorce status from the complainant until the questioning was completed. Therefore, it is recommended that this allegation be closed with a finding of unfounded. Our committee reviewed this, and we do agree with the finding of the Inspector General. And that's it.
Board Member Younger, did you also have case number 2024-1692?
We did.
Okay. I think you started at 1693.
Okay. Case number 2024-1692. This is, thank you. This alleges excessive use of force. The complainant called on behalf of her fiancé and alleged CPD officers used excessive force on him, causing a broken carpal bone, paralysis in his left hand, a fracture in his right hand, 5 broken teeth, and abrasions on his scalp, face, and legs. The DIG's investigation consisted of an interview with the complainant, an interview of the complainant's fiancé, a review of body-worn camera, a review of the use of force report from the incident, and a review of CBD policy and procedure. The DIG, the investigation concurred with CPD's use of force investigation findings that officers' level 1 use of force was within CPD policy and procedure, that the injuries the complainants alleged were caused by the officers did not occur, and that some of the complainant's injuries occurred prior to his encounter with CPD. Therefore, the DIG recommends that this complaint be closed as unfounded. Our committee did review, and we do concur with the findings of the Inspector General. So, I think we have one. How do you want me to do this?
Was it confirmed or just alleged that it was a firearm?
I'm sorry,
It
I
says
didn't.
like he jumped over the fences with what was believed to be a firearm in his hand. Was that confirmed or just alleged?
Can you help me there, IG?
If you give me a few minutes, I'll pull up the report and I'll be able to give you some more information.
Okay.
Well, it says on here that the use of force report stated that he was injured prior to the police contact and had a firearm, was in possession of cocaine, and was charged with weapons under disability.
Okay, so he did have a firearm.
Yeah.
Thanks. What was that case? Okay, yeah,
Okay.
That's it.
Do you want to make a motion then on all those cases?
yeah. Do you want me to, I'll just read them real quick.
If, If
Or
you
do
want, I
you-
can read them.
Okay.
If you just want to, either way.
At this point, we move that all the cases be, I can't remember what I'm supposed to say.
Motion to adopt.
Motion to adopt the findings of the Inspector General as to all the above cases,
Wait, except 0029.
except for,
That
oh,
one, you
yes,
disagreed.
thank you. Except as to,
2025-0029.
Okay, I'll highlight that one and.
Thank you.
We can make a separate one as to that. Okay? We've got open motions to adopt the following cases: 2024-1692, 24-1693, 24-1696, 24-1703, 24-1730, 24-1731, 25-0003, 25-0013, 25-0032, 25-0041, 25-0052, 25-0077, 25-0079, 25-0101, 25-0104, 25-0197, and 25-0201. Do I have any seconds? Okay. Any questions or discussion on those cases? All in favor of accepting, please raise your hands. Okay, unanimous, no opposition, no abstentions. Motion's carry. All right, Board Member Younger for your remaining case.
as to, I can't remember the case. Give me 1 second. As to case number 2025-0029, this particular case, we move to sustain the allegation.
Okay. So we've got a motion on case number 2025-0029 with the recommendation B to sustain the allegation. Do I have a second? Any questions or discussion? All in favor of that recommendation, please raise your hands. Okay. It's unanimous, no opposition, no abstention, motion carries. Thank you. All right. At this portion of the meeting, are there any issues, whether policy discussions or otherwise, that any board member would like to bring to the floor? I'd like to remind everyone that we do have our request in to hear more about the chain of command procedure. I believe Ms. Brock has sent a deadline asking people for questions, so please, if you haven't done that already, think about what questions you would like to have answered at that opportunity. We know that that issue has come up a lot as to what does that process look like on the back end. So please, please, please send your questions into Ms. Brock so that they have things to answer and discuss with us. All right. Again, I've already pointed to our June meeting, which is going to be held at Glenwood Community Center. Again, I'd reiterate the request of the community. If you are interested in serving on the board, we will have applications available and are hopeful that members of our community would like to join. And with that, unless there is any other business, I would entertain a motion to adjourn. May I have a second? We have a second? Okay. All in favor, please raise your hands. All right. Motion adjourned. Thank you.